everyone. Welcome back. It's been a few months. We've got a fresh new look, but I don't want to alarm you. It's still the same fun faces, comedy, and content, but we're coming at you with a new brand. We are now Leave It to Us with Brycie and Christine. So a lot of you are probably wondering, what have these two been up to for the past couple months? Well, other than sunning ourselves, obviously, we have implemented rather 300 new private plan clients for the state of Maine. So we've been very busy there. And with a couple month hiatus, we want to update you all on some of the latest happenings throughout the country. We're going to a little bit more heavily focus on paid family and medical leave, but I'm going to finish you out with an update straight from the Jersey Shore and what some new happenings are in that state with regards to their leave laws. So I'm going to kick it over to Brycie. She's going to talk to us a little bit about what's been happening in Virginia. Very exciting stuff.
Yes, I am so excited to be able to kick off this portion of our episode with my 4 favorite words. I told you so. The last time we recorded a longer podcast episode, it was all about paid family and medical leave and the monumental decision that is, how do we participate in paid family and medical leave? And we foreshadowed at that time, way back in March, that Virginia was on the verge of passing the next statewide paid family and medical leave mandate. So back here with you all. I am thrilled to let you know, if you don't already, that has now come to pass. So today, to set the stage for Virginia for you all, I'm gonna cover the program really super high level, and then just know that in the coming days you will be seeing a lot more of TPG TAM out and about in Virginia, representing us as ourselves, but also assisting our broker partners that work out of that state as well. So at some point, the Virginians will probably be ready to kick us out of there because we're going to get in it. All right. So starting with just a very broad timeline, we had this law pass on April 22nd. That's when the governor signed it into law. And really, no key program established dates between that and from now to October of 2027 is our next big key program date. So between now and October of 2027, what we're going to have is a lot of program formation activity through the state. So the state's going to be working to identify key players. Who are they going to hire to build this program, putting those folks in those key roles, deciding how they are going to administer this program. We had other states either formally or informally consider, like, are we going to set up the infrastructure to run this plan ourselves? Are we going to bring in a third-party administrator like our friends in Maine? And other states, and so there's just going to be a lot of that happening, and I'm kind of waiting to discern how formally that program formation will occur, and more importantly, how publicly that program formation will occur. So it works a little bit different in every state, so we're really starting to dig into how we can expect to keep our customers abreast of what's happening between now and October of 2027. There's a lot to accomplish in that time. I will say generally, Virginia passed this law with a very aggressive timeline. So there's a lot that they need to do in a short period of time. The next key date we're going to hit, as I've said, is October of 2027, which is when the state has committed to us that they will set their initial contribution rate. So how much employers and employees will have to contribute to fund the benefits that will ultimately go out to Virginia employees. What we do know is that whatever that contribution rate is, there will be a 50-50 split between employers and employees for any covered employer in Maine that has over 10 employees. The next key deadline we're tracking towards is April 1st of 2028, and that is when we start paying those contributions into the program. So while we will not know the contribution rate until potentially October of 27, the obligation to start paying hits us right away in April of 28. And that is going to be a challenge for us to get ready, a huge challenge for the private plan community who really likes to know and understand what that rate is going to be before they will start issuing their own quotes. And so this will be a this will be a struggle in Virginia. And then the final like key deadline that we're marching towards is really December 1st of 2028, when employees in Virginia can start to access the benefits under that program. So I'll just say high level, this program will provide benefits to most of the employees in Virginia. The big exclusion in Virginia is actually employees of the state who will be excluded. It's going to provide 12 weeks of benefits as well as job protection as long as an employee's met 120 days of employment with you. And that's going to provide a benefit of up to 80% income replacement to those eligible employees. It's going to provide leave for all of the same reasons we see covered under FMLA, but we're also adding a bucket under the Virginia leave plan for safety leave. So that's if an employee needs leave due to domestic violence, harassment, sexual assault, or stalking, that will now be a covered leave reason under Virginia paid family and medical leave. And then for care of a family member, this law is going to cover family members that are expanded beyond that FMLA definition. And so some of the additional family members that we'll see covered are siblings and grandparents and grandchildren. And then that ever dreaded, they feel like a family member to me. And so ergo, they're considered a covered family member under Virginia law. We do have in Virginia the ability to take leave on a continuous and an intermittent basis. This is common now. We see this in all of the state leave laws that have passed in the last, or paid family and medical leave laws that have passed in the last 5+ years. The ability to access more broadly intermittent leave than what we've had under FMLA. And then the biggie in Virginia is that they will allow us to participate either through the state-run plan, however the state sets that up, or through a self-funded or fully insured private plan. So for those of you who have gone through this in Maine and Massachusetts and Connecticut or DC, like we have some private plan options in Virginia. And so we are going to spend a significant amount of time, Christine and I and our team, helping our customers understand what the right pathway is. And so that's a really quick and dirty overview of what's going on with Virginia paid family and medical leave. And if that wasn't enough, we got another gift in May in Virginia, and that is the passage or really an expansion of the existing paid sick leave law that existed in Virginia that previously covered a very tiny segment of employees in Virginia, but now has been expanded and will cover virtually all employees in that state by 2029. And so we saw that law pass on May 20th of this year. And again, the paid sick leave is going to be provide coverage to all employees of private employers and state and local government. And so we're going to see a phased in approach of this paid sick leave law where by July 1st of 2027, employers with at least 50 employees will be required to comply. By January 1st, 2028, employers with at least 25 employees will be required to comply. And then beginning January 1st of 2029, we go all the way down to one employee. Employers with at least one employee are required to comply with the new paid sick leave law. The covered employers are going to, or employees have to accrue a minimum of 1 hour of paid sick leave for every 30 hours worked. That's going to be the accrual rate, and that kicks in as of date of hire. Employers do not have to allow employees to use more than 40 hours of paid sick leave in a year. And the reasons for the use of paid sick leave are going to be expanded to include services related to domestic violence and sexual assault and stalking. So again, we have that kind of safety time off provision being added to the paid family and medical leave law and to the paid sick leave law in Virginia. So What we do know is that an employer's existing paid time off policy could possibly satisfy these requirements if you're providing at least 40 hours of leave usable for the same purposes and on the same conditions as the statute. So we have a similarity here again between what the state is telling us about paid family and medical leave and paid sick leave is you are required to participate in this. There is no opting out. You can participate via the plan structure that we set up, or, in this case, if you have your own, PTO paid sick leave plan that provides at least as good of what we're setting out for you here, that can satisfy the requirement. For the paid family and medical leave, I will say, you know, we are either participating through the state plan, or we are putting in a fully insured equivalent plan or a self-funded equivalent plan, and the state's going to build a lot of rules around what those plans need to look like. So for the purposes of paid family and medical leave, it's not going to be as simple as our current plans provide the same or better benefits, so we're good. That's a thing for paid sick leave, not so much for paid family and medical leave. And sorry to commingle the two, but it's just too fun. The last thing I want to cover for you, just to give you a jump start on feeling prepared for what's coming at you for the paid family and medical leave law, is just a couple of notes on readiness. So, unfortunately, a huge piece of what we, the employer community, need to understand the impact of what is coming at us with paid family and medical leave is the contribution rate. And at this point, the state it does not have to give us that until October of 2027. And I encourage you, like myself, to start approaching the state of Virginia and asking for that a little bit sooner, please. That would be most helpful. Um, but there
Drafting
are
an
others
email.
what's that, Christine?
I said drafting an email now to the state of Virginia.
Yes,
Please give
please
us the contribution rate ASAP.
draft a polite correspondence to your state representative on that note. There are still things that we can be doing to prepare. So there are understanding the state posting and notice requirements. Some of that is already laid out for us in statute. We're going to start working with our customers on that right away to understand what are we required to communicate about Virginia paid family and medical leave to the workforce. And we could be building the operations for how that's going to look right now. Are we communicating in our handbooks? Are we communicating through LMS systems? Are we communicating? Are we, putting notes on timesheets? We've done some really, excuse me, we've done some really creative things in other states to meet the obligations of that state's posting requirements, and excited to be at it again in Virginia. We will all need to work to understand the financial impact that this new law is going to have to our organizations. And really, again, the key piece we need for that is the contribution rate. We need to know what that contribution rate is going to be to assess the impact to our organization. At this point, though, I will say we can take some good educated guesses. We have a lot of states around us that have established paid family and medical leave programs. We've got some newer states in other parts of the country that have established in the last few years, and everybody's tracking towards the same-ish contribution rates. So we can make some educated guesses there. Another big to-do is updating our policies to indicate how Virginia paid family and medical leave is going to integrate with our existing leave of absence and time off plans. And that is really like operationalizing and building the policy around Virginia paid family and medical leave. Those are the things we can start doing right now. And the more time you spend doing that up front, the more confident you are going to be in getting to April or December of 2028 with a really confident feel that what's going on, how your programs are impacted, how you're going to do things like issue supplemental payments if somebody's only getting 80% of their income through Virginia paid family and medical leave. How do we operationalize getting them that extra 20% of their pay if that's something we're all in agreement that's going to happen? And so that is where I think a lot could be happening right now to prepare. And things that we will already begin working with our customers on.
I love
And
that.
I think that's a wrap for me. That's probably enough.
I feel like this is like enough for the next 3 months. So Brycie and I are just going to take another couple months off here. And Brycie, I'm really glad that you talked a little bit about the like the timeline of this Virginia program. I think that we all feel it's a little tight. I also feel like having benefits available beginning December 1 is an odd start date. It's just weird. I mean, we don't always have January 1. We just saw Maine do it with May 1. But having a December 1 availability date for benefits, again, we're looking at 2028, makes them a little bit more unique. That's for sure. So, yes, we're going to be following all of this. We love it. All right. Well, I am going to transition us to a few more things, paid family and medical leave related, but Brycie, maybe so we can have another, and I'll make my guesses too. So we can do I told you so to each other. But if we could have another I told you so moment, and we did not rehearse for this, do we want to make any predictions on what the next couple states are? So let's recap. We've got Maryland on deck, then we've got Virginia after that are going to go live with mandatory paid family and medical leave programs. What are some of our guesses as far as other states that may go live after these two, or may enact a program, whether?
Yeah, I don't. I will say I continue to gun for New Mexico. They've tried it so many times and just can't
Yes.
quite get it done. So I would love it for the proponents in that state to find some success.
That was going to be mine. And then Illinois was going to be my other one, just because Illinois passed a flurry of very employee friendly leave laws this state. They have some expanded protections for NICU related leave. They have some expanded protections for military related leave. I want to say there were 3 or 4 different leave laws, again, employee friendly ones that they passed this year. So that's another state that's on my radar. So we're going to revisit this to see if we can have another I told you moment. We've probably got a little bit of a runway to see if either of those two predictions come through. So let's talk about some updates. I'm just going to go through this like pretty quickly, but let's give you all some updates on existing paid family and medical leave programs, particularly with regards to some of the maximum weekly benefits. For those clients that are listening, you've probably already gotten some communication from us on this information. We're also going to be talking about it in our next newsletter. But for those newer listeners, we are super excited to break this news for you. So real like cutting edge journalism that we're bringing your way, but a few states to talk about. So Colorado, Oregon, Maine, and Rhode Island, they all have increases to their maximum weekly benefits for paid family and medical leave that are effective July 1, 2026. And I'm not going to go through all the numbers. I feel like that's a little bit too much for everything that we've covered so far. But the one thing that I want you to keep in mind is Colorado does things a little bit more uniquely when it comes to applications of this new maximum weekly benefit. So what Colorado does is they make changes apply to all new and open claim payments made on or after July 1, 2026. Contrast that to our friends in Oregon and Maine. The changes to the maximum weekly benefit are only applying to new claims submitted on or after it's either late June or early July, depending upon which one of those two states that you're in. So it's a little bit different approach. So what this means is that in-flight claims in Colorado, so those claims that started prior to July 1 and carry over post July 1, those existing in-flight claims could actually have an increase in maximum weekly benefits. As you can see, states put together these rules like whichever way the breeze blows. I mean, that's really what it seems like, because we don't have consistency from state to state, but it's why it's so important to understand some of these different nuances, particularly if you are supplementing wages, because again, those in-flight claims in Colorado, you're going to have a change from the supplementation amount the last part of June into the first part of July. So keep that in mind. If you're interested in any of the specific numbers, you can email Bryce here. We will absolutely get you that information. Increases to the maximum weekly benefit are something that occurs most frequently on an annualized basis. Almost all the programs increase their maximum weekly benefit on an annualized basis. It's typically like a negligible amount. I would say generally like less than $100. I shouldn't say that's negligible, but less than $100 is on average what we're going to see. And it's driven by adjustments to the state average weekly wage, which again is an adjustment that is made on an annualized basis. For some of our other states, we see changes to these benefits amount happen January 1. But like I said, we've got these 4 states that are all going to be happening July 1. So please keep that in mind. And then I want to round you out with an update from the Jersey Shore, if you will. I don't know if you're of a certain age. I don't want to claim that I actually like spent very much time watching this show, but if you did ever watch the Jersey Shore, you're familiar with GTL, which I think is Gym Tan Laundry. That's not what we are going to be talking about today. But what I do want to tell you about is some significant law expansions in the state of New Jersey that are going to be effective July 17th. Yes, July 17th. I had to sneak at my notes real quick. So it's coming up very quickly. And these impact not only temporary disability and paid family leave, but we also have some adjustments to New Jersey Family Leave Act, which is the unpaid job protected leave law that New Jersey has for its employees. So first big change, temporary disability insurance and family leave insurance is now explicitly job protected. So in the state of New Jersey, it wasn't previously explicitly job protected. I feel like this is kind of an insignificant change simply because a lot of times if these programs don't offer explicit job protection, they still have very strong anti-retaliation language. And so even when we don't have job protection in place because they have the anti-retaliation language, you're still going to hear Brycie and I say, hey, you should still treat this as a job protected leave if your employee is accessing this benefit type. So again, in July, the New Jersey Family Leave and disability insurance do come with job protection. So that is a way apparently that they are going to celebrate America's 250th birthday by providing job protection there. And then the other big one is New Jersey Family Leave Act. Again, that's the unpaid. It's like New Jersey's own version of FMLA. The way that that policy is currently put together, or what the legislation currently states, is that eligible employees get up to 12 weeks of unpaid job protection in a 24-month period. For anyone who operates in New Jersey, I think you know that figuring out that entitlement over a 24-month period is very difficult because pretty much everyone else is 12 months, but that's neither here nor there. So eligibility for that program historically, or rather until mid-July, is employees can take that leave if they work for an employer who employs at least 30 employees and they've been employed for at least 12 months and have worked 1,000 base hours in that preceding 12-month period. New Jersey, effective July 17th, it is going to expand coverage to smaller employers with fewer employees, and it's also going to lower the number of months that an employee must be employed to be eligible. So the definition of an employer, I previously said it's 30 employees. The definition of employer is now going to be 15 or more employees for each work week during each of the 20 or more calendar work weeks in the then current or immediately preceding calendar year. Yes, I am cheating with some notes there, so please bear with me. But that number is being cut in half. So we're going from 30 to 15 employees for employer coverage. And then for employees to be eligible, they need only 3 months worked and 250 hours worked during the preceding base period. So what New Jersey has done, and again, we always love to contrast this to what we see in other states, is New Jersey has now given us the lowest threshold for eligibility for New Jersey's version of FMLA. Previously, that award, I don't know if it's an award, but it went to Oregon. So Oregon currently has eligibility of their Oregon Family Leave Act program of 180 calendar days and 25 hours worked per week. We have significantly lower in New Jersey right now. So sorry, Oregon. There's a new queen in town. It's New Jersey. I'm sure Oregon and California are now going to want to try and jump on these bandwagons and trying to change their own leave laws to lower the eligibility threshold, but we'll see what happens. So those are the biggies happening out of New Jersey. The other thing that I think is really important to talk about in New Jersey, and this one I will tell you, we actually we did a phone a friend on. We engaged counsel on some interpretation here because we were struggling a little bit in how to interpretate this. So the new law, what it is allowing employees to do, again, this is the middle of July, is that employees have the option to use New Jersey earned sick leave. So New Jersey has regulatory paid sick leave, or receiving TDI or family leave benefits and control the order of such use. Okay, so again, this is unprecedented. Let's unpack this a little bit. So what this means, your employees in New Jersey, they can tell you, hey, for my first week of leave, I just want to use my regulatory paid sick leave. I am not going to apply for temporary disability or family leave, depending upon what the leave circumstance is, or vice versa. They could say, I'm going to use TDI or FLI. I want to save my New Jersey earned sick leave for a rainy day or other qualified such reasons. And part two of this is employees cannot receive more than one kind of paid leave simultaneously during the leave period. And this is where Brycie and I said, wait a second. Does this mean that an employee could not supplement their TDI or family leave benefits with available regulatory paid sick leave that they have from the state of New Jersey? And the interpretation is that yes, employees are no longer able, and I'm using the word interpretation because I don't think this is the intent of the law, but this is how it's written. Employees are no longer able to supplement their TDI or family leave benefits with their available sick. The way that this amendment is written, and it's our interpretation, and we've gotten counsel interpretation as well, is that it actually prohibits the use of those two leave types being applied at the same time. Again, I don't think this is the intent of the law. This is a very squishy topic. I think that New Jersey probably wants employees to have the ability to access 100% of their wages between a combination of the two when they're off of work for a qualified reason, but that's not how the amendment was written. So we're kind of watching this. We know that some of you listening have a very heavy population in New Jersey. We've had some really robust conversation with our client base about what this looks like, but it is a biggie. So just some like light content to drop on your day. This was a lot, Brycie.
Yeah, it was a big one. It was a technical one. So thanks for those who stuck with us to the end here. And I am going to drop just a fun challenge to our audience and to Christine and our marketing team. And thank you in advance for being good sports. But we want to figure out a way between now and maybe the next time we record to get some feedback from the audience on, we've had several episodes that we've released. I'd love to know what's resonating and really what you want to hear about in the space of leave and accommodation. The world is our oyster. There's so many things we could be discussing in this format. And so we're going to put our heads together and figure out a way to get your input on what you want us to be talking about next. I know we've done a lot of paid family and medical leave is a favorite topic of ours and always keeps us busy and armed with new content. We've done some kind of FMLA ADA 101. We've done some relevant case law, but very interested to know what you, the people, would like to hear from us.
Yeah. Thanks everyone for tuning in. Happy summer 2026. The information provided in this podcast is for general information and education purposes only. It's not intended to be and should not be construed as legal, financial, or human resources advice. While we strive to provide accurate and up-to-date information, laws and policies regarding leave management vary by jurisdiction and may change over time. Listeners should consult with a qualified attorney, HR professional, or relevant expert for advice specific to their situation. The views and opinions expressed by the hosts and guests are their own and do not necessarily reflect those of their employers or any affiliated organizations.